Suspended Public Protector Busisiwe Mkhwebane and his legal representative, Dali Mpofu, are not recognized for their loyalty to the truth or the law. It is not surprising, therefore, they claimed last week that Office of Public Protector's refusal continue to pay escalating legal costs was part of a campaign defame and humiliate Mkhwebane. An impeachment investigation continues in Mkhwebane's absence. Legal representatives will be illegal, unlawful and unethical and will be a violation of Mkhwebane's rights. In reality, facts and the law do not seem to support these claims. However, it can be argued that any Chapter 9 public official facing an impeachment investigation should be entitled to payment of reasonable legal costs incurred in course of such an investigation. The first obvious point to note is that Constitutional Court has not ruled, as suggested, that Mkhwebane is entitled to legal representation of his choice, at the expense of state. The Public Protector did not raise issue of who would bear costs of such legal representation before Supreme Court or Constitutional Court, and no court considered this question. In Speaker of National Assembly v. Public Defender and others, Democratic Alliance, Public Protector and other Supreme Court overruled National Assembly rule allowing legal representation before impeachment committee, provided that legal practitioner or other expert does not participate in committee. The court changed rule read that the Article 194 committee must grant a holder of public office right to be heard in his defense and seek assistance from a lawyer or other expert of his choice. The court pointed out that in our law, there is no right of independent or absolute legal representation in a court other than courts of law, but decided that it was unreasonable for the National Assembly rules to allow full legal representation for a person. The President who appears before an impeachment committee Chapter 89, but not for Chapter 9 officers who appear before an impeachment committee Chapter 194. However, court also requires that the committee conduct investigation in a reasonable procedural manner under Rule 129 AD and that a reasonable fair procedure requires full legal representation for a public official facing dismissal. Therefore, it could be argued that state has an ethical duty to fund the reasonable cost of legal representation of any Chapter 9 officer appearing before an impeachment committee to ensure that process is reasonable and fair. But that is not the claim made by Mkhwebane and his legal team. Instead, they seem to argue that the state has an unlimited obligation to cover any legal costs incurred by the holder, no matter how exorbitant. Spiral costs. It's indisputable that Mkhwebane's legal costs are spiraling out of control. Last Friday, Acting Public Protector Kholeka Gcaleka, in a letter committee, disclosed in a letter to committee that 194th chapter investigation pre-trials, as well as total expenditure on legal fees related impeachment process, were made for 202,223 fiscal year. Came to about 26.2 million. It's unclear how much of this is spent on litigation aimed at halting the impeachment process and what percentage on committee proceedings, but it was previously estimated that Mkhwebane's 5-person legal team cost around 130,000 per day. The Public Protector's Office also previously raised further questions about the exorbitant cost incurred, citing inconsistencies in the bills submitted to him by Mkhwebane's legal team. Since Mkhwebane is not a poor person and the office the Public Protector has already spent millions of rand on his legal fees, it cannot be argued that he is a vulnerable person in need legal aid funding. Ideally, Mkhwebane and his lawyers should take steps to avoid current stalemate by reducing legal costs to ensure that funds provided by Public Protector's Office last through end of process. Failure do so exposed Mkhwebane accusation that he was responsible for own misfortune and could not complain about the withdrawal of his legal representatives because he was unable to manage resources available him conduct defense. The real question, however, is whether the solution the problem will be to apply Legal Aid South Africa for limited funding. Support for this view can, at first glance, be found in various Supreme Court and Constitutional Court decisions regarding the financing legal representation of Marikana miners before the Marikana Commission Inquiry. Recall that High Court in case Magidiwana and Another v. President Republic South Africa and others ordered Legal Aid South Africa take steps secure legal funding Marikana minors allow them join Marikana Commission Investigation. While court held that the right to legal representation on commissions is not absolute, it said refusing to raise funds could be illegal, but it would depend on specific context. At Daily Maverick, where are you, Dolly? A tough week full of tough questions from Mkhwebane, the vulnerability of applicants as participants in the commission proceedings and need for each party to be given a reasonable opportunity to present its case in conditions that would not put it at a significant disadvantage. His opponent were determining factors in the decision of court. However, since Mkhwebane is not a poor person and the office the Public Protector has already spent millions of rand on his legal fees, he is hardly a vulnerable person in need legal aid funding. Financing issue. Another problem is the High Court characterizes its decision by making it clear that Marikana minors are not entitled to unlimited funding and the court cannot determine how much funding to provide legal aid. He simply suggested that it would be commendable for legal aid to fund the firm of 2 lawyers and a law firm. Legal aid cannot therefore be expected to finance Mkhwebane's legal costs at the same level it has ever financed. Both constitutional court rulings on matter cast doubt on whether the ruling will help Mkhwebane, as makes it clear that Supreme Court ruling is less comprehensive than seems. First, Constitutional Court in Magidiwana and others v. President Republic South Africa and others, which dismissed appeal and urgent appeal, stated that injustice may arise if adequate legal representation is not provided, but this means that courts have power to instruct executive branch government on how state resources are to be used. Secondly, Constitutional Court, which dismissed appeal of Supreme Court decision quoted above, found that in South Africa v. Magidiwana and others, Supreme Court decision did not impose any general obligation on legal aid to finance legal representation, and that did not fund such legal representation. He retained the discretion to decide on a case-by-case basis whether or not to do so, and concluded the Supreme Court's decision will have no practical impact on any of the parties, particularly its future decisions regarding legal aid and funding. If parties appearing before a similar commission in future need legal representation at the state's expense, they will need to apply to legal aid, which will evaluate application in terms of relevant laws and regulations. If application does not meet the funding requirements, legal aid will be free to reject application. Assuming that the ship has sailed and Mkhwebane is solely responsible for running out of money to pay his legal team, should the committee continue its work? It would be desirable reach a compromise, provide limited funding Mkhwebane, allow him pay a much smaller and less expensive legal team represent him. If he refuses accept it and uses the legal funding issue to avoid cross-examination, the committee will have sue him. This would be in line with position judges presiding over Court of Judicial Ethics, as set out in Section 28 Judicial Service Commission Act. At Daily Maverick, Dali Mpofu's defense of Busisiwe Mkhwebane slips on very thin ethical and legal ice. The section states that judge presiding at such a court has right to attend hearing and receive assistance from legal representative, but court may initiate or continue hearing whole or in part defendant's absence, or, if court considers that defendant has been appropriately informed of hearing, defendant's legal representative, or both. As Mkhwebane has often argued that should be treated the way judges are treated, he should have no objections to this, unless, of course, uses the funding issue to avoid something that could turn into disastrous cross-examination. DM